Patricia Redmond, I've known her as Trish as long as I've known her, and I've known her 35 years. If it's not 35 years, it's 34 years. It's a long time. Is with the Stearns Weaver firm in Miami, Florida. And the decision to ask her to come join us this evening as our keynote speaker was really very easy. She is the 2015 recipient of the Bankruptcy in Alliance Distinguished Service Award. That's the same award that Judge Drake received at the National Conference of Bankruptcy Judges this past October. And when I talked about Dennis Conley and Dave Berry earlier, that's their committee that was integrally involved in making the nomination that led to Judge Drake getting that award. That award is a combined award that is given by the American Inns of Court with a focus on bankruptcy and the NCBJ. So it's the National Conference of Bankruptcy Judges and the American Inns of Court coming together to say, in your life, you've done things that are special, and you've really provided tremendous service to the bar, and we want to recognize that. And that's why picking Trish was easy. The other thing was, I knew when I called her, she'd say yes, because that's the way she is. Trish is a past president of the ABI. She's an adjunct professor at her alma mater, the University of Miami School of Law. She co-founded their bankruptcy assistance program. That's their pro bono program. She was a speaker at the SBLI this year. But to be candid, if I went through everything that was in her resume, it would take me 20, 25 minutes to go through it. It's, 5, 6 pages long, and it's filled with a wonderful number of tremendous lifetime achievements. The professional creed of the American Inns of Court was the basis for the Inns Alliance Award, and it contains the following recital. It says, whereas preservation and promulgation of the highest standards of excellence in professionalism, ethics, civility, and legal skills. The highest standards of excellence in professionalism, ethics, civility, and legal skills. That's what we're supposed to be about as lawyers. That's what we're supposed to strive for individually. And that's part of the creed of the Inn of Courts. And it says, are essential to achieving justice under the rule of law. Well, our inn was based and was created in furtherance of that creed. And the idea is, who can we have that's actually walked the walk, that's an active practitioner, that engages in this type of activity every day and in every aspect of her professional career? And I know, because the reason we became friends over 30 years ago is we were on the other side of a case together. And it's better to become friends with the people that are your adversaries than not. That has never been one of my strong points. But with Trish, it was one of her strong points, and that's why we've been friends this long. And it is thus with great pleasure that I am able to ask you, Patricia Redmond, to come on up to the podium and talk to us. Thank you.
Thank goodness the microphone's fixed, right? Okay. Good evening, Judge Drake, judges, Grant, students, professors, all the people who are here at the Inn of Court. Inns of Court have been a significant involvement of mine, although we don't have a bankruptcy Inn of Court, and I'm envious of what you've all been able to accomplish here in Georgia. And I'm now really committed to go back to Florida and try to put this together for Florida as well, so we could be half as good as this inn is. But Inns of Court is the vehicle through which senior lawyers, junior lawyers, and students get together and break bread, talk about things, can you hear me? Okay. Give advice to one another, and so on. And it's a wonderful, wonderful thing that was created in Old England and survives now in the United States. But before I begin, when Grant asked me to come tonight, I was wondering, I wonder why Grant requested that I come and address the Inn on civility. And yes, civility's been an important part of my practice, but I thought of three things. One, well, because I'm from Florida, and the lack of civility is so bad there that we have a special rule from our bar that says that you can be punished for not being civil. A lot of the bars have an aspirational goal that you should be civil and professional, but no, ours is enforceable. Or because I've been practicing over 35 years and I'm old, so I must have seen everything with respect to civility back in the day, and the lack of civility that people talk about today. Or because I've been teaching for 19 years, and I know students. I've watched students, and I know that they are sponges. And part of my message tonight is going to be consistent with what Grant was saying, and that is mentoring is the answer. It's the beginning, and it's the end. And it's the way to make young people civil and to make our practice the civil practice we want. My second story about tonight is that I'm on a blog, and it's a civility blog of the ABI. ABI did a commission on civility and professionalism, and from that, there's a blog that judges and lawyers participate on. And today it was suggested that the group get together and put and write a civility cookbook. So you'd have a recipe here, and then you'd have a civility saying underneath the recipe. Everybody really liked it until someone raised the issue of jerk chicken. And they said, is that uncivil to call a chicken jerk? Is that something that we ought not be doing and we ought to consider? So that was one that's still going around, but I think that there will be a civility cookbook at some point. So getting to how I started to put my remarks together for tonight and understanding that Patrick Henry was here last year, and this is such a hard act to follow. And I'm not an actress, so that's going to be even more difficult. But I looked at the ABI Commission's recommendations for professional civility, and I thought that if you look at them in the context of what mentoring is, remember that students don't know anything. I remember in my clinical class sitting in my office with a student, and my adversary called on the phone. And at the end of the conversation, the student said, "You were so nice to them." I said, "Well, yes, our clients are adverse, but we're not adverse." And they were stunned because they didn't know. That's the kind of teaching, that's the kind of modeling behavior. And it's not just you all who are parents know. That it's not just that people learn what you wish to teach them. They learn what they take from you. They'll model what you do. So if you say, do this, not nearly as effective as actually doing it and having someone see you do it. So the first one of these principles, real easy. Professionals should be courteous and civil in all professional dealings with other persons. It's easy. But what does it really mean? It means we live in an adversary system, but lawyers aren't the adversaries. Our clients are. And lawyers can be above that. How many times? I bet just about every time you get into a case, you look and see who's on the other side. And why do you do that? Because the hardest case can be easy if you've got a good lawyer on the other side And the converse is true too. The easiest case can be so difficult with a bad lawyer on the other side. So looking and seeing who the other lawyer is makes all the difference in the world. Another is disagreeing without being disagreeable. That's an important thing. I notice sometimes when I go and visit other law firms that a lot of the groups, when they're working on a case together, start to name their opposing counsel with names like Darth Vader, things like that. And it's interesting. That also is going to be something that's modeled by the younger lawyers. When you do that and call people names, whether they be derogatory or not, all of a sudden, everyone looking at somebody else in a negative light. And the last is, of course, this is mentoring, supervising people and making sure that when you do things, that the people you supervise live up to the same standards. The second principle is that when not inconsistent with clients' interests, professionals should cooperate with other professionals in an effort to avoid litigation and to resolve litigation that's already been commenced. Now, I think one of the most important things in terms of affecting this particular civility rule is the meet and confer. In our district, we have a requirement, not just in discovery issues, but in any issue that you bring before the court, that you meet and confer and talk to the other party about what you're bringing before you go to court. Now, Judge Isikoff tells the story of how important this is because she says she was sitting on the bench one day, two lawyers are arguing, and 15 minutes into the argument, she realized they didn't disagree. And she looked down from the bench and she said, "Have you two talked to each other before you came here?" And they had not. And once they realized what each other were saying, they were fine and the case resolved itself. But a meet and confer. I have asked judges, and to those judges' credit, they have done that where the opposing party has not sought to contact me before filing and try to resolve it, to continue the hearing for that process to take place, and some of our judges have done that. And I think it's very effective because you're making people talk. When you communicate, you find out if you do agree and to what extent you agree and if you disagree. Okay, so the next one is professionals should respect the schedule and commitments of others consistent with the protection of their client's interest. This is the standard continuance. Hi, I need a two-week extension. I've got something going on in my life. I'm moving my father-in-law to another facility, things like that. And easy to say, especially when it's the first one, these rules of civility basically say, first continuance, it's really hard to deny that unless there's some really compelling reason for your client. But last week, I had a circumstance where a lawyer called and said, I need a 2-week extension to respond. And I called my co-counsel, and they said, well, we're really worried that in that 2 weeks, they'll file a proceeding either in the Cayman Islands or in another jurisdiction and try to divest our judge from having control over having jurisdiction over the case. And so what we did is we went back and we said, happy to agree, but we'd like you to agree not to file motions in any other court or in this court during that time and to maintain the status quo. Answer, everybody was happy, the extension was granted. So even when there are compelling concerns for your client, there are ways to address those at the same time as being professional and agreeing to the continuance that was warranted. The next, a professional should not initiate communications with the intention of gaining an advantage from the recipient's lack of immediate availability. A Friday afternoon email. And again, remember, the young people in your office, if you do this, see you do this. All of a sudden, this big tomb of issues that gets raised with opposing counsel on a Friday afternoon. Why? Because it's designed to ruin someone's weekend. That's not what we're about. We're about something way better than that. We're about trying to achieve things that are going to be positive. We're trying to get to resolutions. We're not trying to ruin someone's weekend, but it happens a lot. And the practice you see again and again. And I'm here to tell you that, we can rise above that, and we certainly want to teach our young people to do the same. The email that creates a lot of issues the day before somebody leaves on vacation, right? If you're a lawyer and you plan a vacation, everything goes wrong. Every case that you have decides to heat up before that vacation. And so it becomes a real problem for you. So that's another thing. Or when somebody is on vacation when you know they can't do anything about it. Again, all that sends a message to the kids, to the younger people. I call them kids because I've been teaching so long, I just call them kids. And really, they start to call themselves kids because they get used to me saying that. But it sends the same message to them. Okay, the next is a professional should return telephone calls promptly and respond to communications that reasonably require a response with due consideration of time zones and other known circumstances affecting availability. When I was a brand new associate, now some of you will remember this because I know some of you are practicing even longer than I've been practicing, but my immediate boss, the partner, used to walk around with a wad this thick of paper messages. Remember paper messages? You young people out there, you don't even know what they are.
They don't even know what a phone is.
They do not know what a phone is. And that's another thing. It's a really good way to communicate and a good message for young people. But paper messages. And the truth was, it was so big because he didn't call people back. He ended up with having 4 and 5 of the same message in this wad of messages. But we learned from that. And he spent half of his time explaining why he didn't call people back. Now, when I started, I used to think that I had to have an answer for everyone to call them back. And if I had an answer, I'd be back to people in a heartbeat. But I didn't have an answer. I'd start to look for it. And I realized that the courteous and civil thing to do is to call them back and say, I don't have an answer to your problem right now. I'm working on it. I should have it tomorrow. And then the person knows that you haven't ignored them. They feel that what they sent to you is important and you've acknowledged it. And again, you've taken your practice to a higher level. Okay. Next is the timing and manner of the services of papers should not be designed to cause disadvantage or embarrassment to the party receiving the papers. I have a really unfortunate circumstance to tell you about. When I was ABI president, I was involved in a case. And as ABI president, I had to go to a lot of the conferences. My opposing counsel knew that I had to go to conferences. And in our case, there was a discovery rule that if they produced a certain request to us, we had 5 days to respond. At the time, I represented a receiver who was the custodian of a lot of records that might have had privilege issues for other parties in the case. And so as soon as there would be an ABI event that they knew I was at on a Thursday, sure enough, that notice would come in, and I'd have 5 days. So I have to scramble, get home on Sunday, go into the office, and get it done by Monday. And so, and that's the kind of thing. Yes, they had an advantage. I was scrambling, and I was defending. But it just took all the professionalism and civility out of our relationship, and it really took the respect that I would have for everyone in this room and most of the people I deal with out of the relationship for that lawyer. Okay, the next is a professional should not use any aspect of litigation process, including discovery and motion practice, as a means of harassment or for the purpose of unnecessarily prolonging litigation or increasing litigation expenses. I had 2 cases that came into bankruptcy, and both were state court litigation. And they ended up in bankruptcy because the debtor had been the plaintiff and had spent so much time and expense litigating against the defendant. The defendant had given an offer of judgment so that they could get attorney's fees. If they ended up the winner, the defendant won, and the plaintiff had a huge judgment against them and ended up filing bankruptcy. That's the kind of thing, scorched earth litigation, wasting people's time, wasting courts' time. That's so below what we ought to be doing as professionals. Our job, and especially as bankruptcy lawyers, our job is to get a job done. That article that you see about the bridal case was my attempt, which everyone in this room would have done the same thing, because we are all can-do people, and if you see a problem, you reach out to try to solve it. I saw a problem that I could solve, and so I tried to do it. But that's really what's really important. Let me move on to the next one. It's in out-of-court proceedings, professionals should not engage in any conduct that would be not appropriate in the presence of the judge. Well, this is fun. I was in a case years ago. I don't know, some of you may remember, Prime Motor Inns and Cervico were huge hotel cases that filed in the Southern District of Florida. And when the judge would walk out of the room and say, you all talk among yourselves and try to resolve this, it was like one of those cartoons where the floor turned over and the parents walked out and the band started and the party started, and as soon as they opened the door again, it turned into a nice, quiet living room. The lawyers started screaming at each other. And the judge walked back in, and it was like, okay, so somebody flipped the light on and people started acting professionally again. That's, a good rule of thumb is to assume the judge is always there. And this was in the day before there were microphones in the courtrooms. Now you have to put your head over the microphone if you're going to do something like that. Okay, and the last is a professional should keep his or her word. Giving your word is so important. Sometimes you just can't finish something or can't do exactly what you promised. And when you do that, you all know what you do. You finish the day and all of a sudden you've promised some document to opposing counsel or your co-counsel by the end of the day and you don't finish it. And so all of a sudden, you pick up the phone and say, that's the phone, Judge Bonifel. Pick up the phone or email and say, didn't get it finished. Really sorry. I'll get it to you first thing tomorrow morning. Rather than saying, oh, they'll figure it out, that I didn't get it finished and they'll get it tomorrow. And then what you've done is a couple things. You've created a circumstance where everyone knows you're good for your word. And if you say something, that they can go to the bank on it. And that's kind of another element of civility. Being able to trust the people that you deal with. Being able to know when someone says something that they're going to be true to their word. And the last is a professional should not mislead others involved in the bankruptcy process. And that includes the court. A professional shouldn't say something to the court that's not true. And courts have the opportunity. When a court senses something's going on or somebody is misrepresenting something, to really take the time. And courts don't like to do that. When lawyers start to squabble over who's telling the truth, judges say, move on. Let's get to the issues before me. But sometimes when a lawyer misrepresents something to the court, if the court doesn't look at it, what's the result? Somebody just did something and they got away with it and they're emboldened. And so next time they'll do it again and maybe a little worse the next time and test the limits one more time. And so something that, judges I know don't like to deal with this, but if judges keep the level of practice high in their courtroom and don't tolerate people that aren't truthful or even insignificantly misrepresent something, the level of practice will get higher. So I guess in closing, as I started to ask people to get prepared for today, I said, what do you think about when you think about civility? And everyone starts with, back in the day, in the old days, when you went to work for a law firm, people were respectful, people were civil. You went to a law firm, and you know what? You stayed there for your whole professional life. The law firm was like a family. You invited the partners, you invited the associates to social functions. Everybody dealt with each other regularly. Clients stayed with law firms. Imagine that, for generations. The same client went to the same law firm. It was a lot different. There was trust. I remember having a trustee object to my client's proof of claim. And what I did is I called him up, yes, on the phone. There was no computers back then, and said, hey, I've got the supporting documentation. I'll send it right over. And he said, no, Trish, if you say you've got it, that's good enough for me. Can you imagine that happening today? Never happened today. But that was the good old days. During that time, lawyering was taught. And this takes me back to my theme of mentoring, by senior people, mid-level people, to junior people. People didn't learn skills. In the old days, you learned how to be a lawyer. You learned how to lawyer, how to counsel, as your senior people did. You were little sponges, and you modeled what they did. How often have you seen a younger lawyer adopt the mannerisms of the senior person? Because it's like a duck and ducklings. They're like following along and doing the same thing. It was a very, very different world. But today's different. Today, you have people in multiple offices. Sometimes you don't even see the person who's giving you the assignment. You're not working side by side with people. What does a young associate have to fear today? Artificial intelligence. We never had to do that when we were younger. But the real difference between artificial intelligence and an associate is the thing they can learn, the thing that you learn here, civility and judgment. Artificial intelligence can do the research, they can draft the contract, but they can't exercise judgment. And judgment is what mentoring is going to be able to teach the younger people. Those kinds of calls, not just what you can do, but what you should do. My younger partner came to me and said, I'm 9 years out now, and all my colleagues and I, we're pretty confident. We've got the skills down. We can do everything we need to do in bankruptcy court. But we don't necessarily know when we should, or if we should, and when we should restrain from doing something, and what really matters. And so that's what and that's what mentoring has been for me. I've been so, so lucky to be able to be surrounded by incredibly brilliant students who challenge me every day, who grow up to be bankruptcy lawyers. I am the only person in the Southern District of Florida in my generation who knows all the young people, because they were all students. To watch them grow and to watch them start to mold themselves into what will be great lawyers. And what was really impressive to me is when one student said, WWPRD. I'm there, what is They have acronyms for everything. WWPRD, they said, well, that's what would Professor Redmond do? I'm there, wow, that's a big responsibility. I never thought they watched me like that. I mean, what would I do would be what would guide their decision, and it's true. It's true. We have such an ability to mold the people who are young people that, it's just an opportunity that should not be missed. So with that, I really want to thank you. You've been so welcoming to me tonight, and it's a pleasure to be here.
Thank you very, very much. We are moving towards the next section, which is Judge Smith and Walter Kelly, and you both can come up together.
Oh, wow. Professionalism, ethics, civility, excellence. Professor Redmond, you get it, okay? You get it. And luckily, I have personally interacted with most of the people in this room, either as a practitioner or as a judge, and I can honestly say that you here in this room have demonstrated your commitment to this mission. I have personally experienced and witnessed how you have conducted yourselves with civility, excellence, and professionalism. I am here tonight to encourage you to promote the spread of that level of excellence through active participation in the end, because our mission of excellence will not be achieved in a vacuum. It will require work and participation. I want to give you a personal experience. And Walter, I don't think I've ever told you this, but when I was interviewed by the 11th Circuit for my position, I talked about you. And Judge Dabena, who was Chief Judge of the 11th Circuit, said, Jim said, we don't have any problem finding people who've got the smarts to be a bankruptcy judge. What we're really concerned about is their judicial temperament. How can you convince us that you will have the proper temperament? And I said, I knew the question was coming. People had told me this is one of the things they asked, and I thought about this mowing grass for all summer long. I do a lot of closing arguments on the lawnmower. And I said, well, I understand the question, and your question is near and dear to my heart, because I can tell you that if you don't select me, the person you do select will be my judge for the next 14 years, and I want to make sure that that person has the right temperament. And so I talked about my life and how I thought I had demonstrated the proper temperament, and I said, but I got to tell you, I failed one time. I had a case in Thomasville, Georgia, and I had a very difficult client. It was a Chapter 11 case. It was a client that we've all had, or if you practice long enough, you will have, that would not do what you say, was always late, wouldn't listen to you, and it became obvious that their Chapter 11 case was not going to be successful. And so we convinced this person that the best thing to do was just dismiss the case. There were no assets in the case, there was no equity, and so there was no reason to convert it. And so we filed a motion. I went down to Thomasville to have the hearing, and Walter showed up representing his client, who was a creditor, and they objected. And I was so ready to get out of this case. And I was so upset with Walter. And I was rude to him. And I don't remember exactly what we said, but I was not a nice person to Walter. We did resolve it, and the case got dismissed. And on the 2.5-hour trip back to Macon, I literally beat myself up about what a nasty SOB I had been to Walter. When I got to the office, I immediately pulled out my stationery and I handwrote you a note apologizing for how rude and unprofessional I had been. And I sent it. Now, this was before the days of email. This was like 83, 84. 2 or 3 days later, that's how long it took back then, Walter got the letter, and he called me. This was in the day when long-distance phone calls cost money, okay? He called me and he said, Jim, I just can't tell you how much I appreciate your sending this letter. He said, but it was just totally unnecessary. I understood. And I said, Walter, it was necessary. I didn't act right. And he appreciated it, thanked me. Now, I tell you that because there were two things going on here. Number one, Billy and Gita Smith in Dawson, Georgia had raised me right to be not a rude person. But number two, I had a senior partner, Jerry Kaplan, who explained to me that the fight is between the clients, that we're lawyers. You can have an all drag-out fight with a lawyer on a professional and civil level and walk out of the room and still be friends. It doesn't happen in a vacuum. We have to mentor these people. And so we have people who are in charge of mentoring. I think it's Alex Sanders, Colin, Bernardino, Jim Drake. If they call you and ask you to be a mentor, volunteer, please. We need mentors. If you're called and asked to serve on a board, serve. If you're called and asked to speak at a educational function, please participate. It won't happen in a vacuum. And the practice of law is so much nicer when you're nice to people and they're nice to you. So that's my message to you. I look forward to being your president this year. Walter, turn it over to you, buddy.
Thank you, sir. Thank you so much, Joe. I appreciate that. Man, I appreciate those kind words, and it wasn't necessary back in those days, but I do appreciate it. And I want to tell you something, y'all. I had the best mentoring experience of anybody when I picked Nick Garcia as the first mentee, and that was several years ago when Jim Frenzel asked us to do this. And we have been great friends ever since then. He clerked for Judge Laney and has been a great guy and a great influence. And I want to thank all of y'all for everything that you have done and all the things that you will do, including Judge Smith, who is now the president. I want to thank Judge Paul Bezier, who is the president-elect, and Rob Williamson, who is the counselor-elect. And Rob is also taking over from me as the secretary. And our treasurer for life is Kenny Stone. And it's just hard to get people to do stuff, but Kenny will do it, and he does it well. But I want to thank all of y'all for that. And y'all, this is a fun group. It really is. And thank you so much, for your comments on professionalism. And it really is a joy to be here. We're all lucky that we've got so many great people in this end. And the beauty of it is that it just gets bigger and better every year. But one of the best things that I get to do as the counselor is to thank the people who came before us. And I want to begin by thanking Judge Bonnefeld. And let me go get something. I put this together for him. Hold on. Where is his honor? Oh, here we go. All right. To Judge Bonnefeld, I thought about, and I've called my buddies, I called Kathy Horn and a bunch of other people. I said, don't you think another plaque would be great? Or maybe some cufflinks? I said, no. So I got him this basket with a little wine and a great songbook. This got your favorite song that you sang at the NCBJ. And you know what it is. So thank you so much.
Thank you so much.
And I also have a little note to you that you can read later. But that is just it's like Jim did to me. That is my thank you note to you for everything that you have done for this end, and that you will continue to do.
Thank you. You shouldn't have done it, but I'm glad you did.
Now, Grant was a little harder. So, here is my thank you note to you.
Thank you.
But in this, I had to call around to different parties to ask, now, what would Grant really like? Like cufflinks and that sort of thing. No, do not give him. He likes wine, he likes a little scotch, and cigars. So here you go, buddy. Let me tell you, this guy is hard to follow. He is going to be really hard to follow. He has burned up that email trail, and I'll try to follow in those footsteps. But the beauty of what he has done for us and what Judge Everybody really, is that they put everybody together. We've got these programs all lined up. We've got 7 programs coming up. They're all good programs. Judge Bonifeld might perform at one of them. I don't know, but perhaps he will. There's some great songs in that book, by the way. Really good songs, and I know about a third of them. And this 2018, 2019 year is just going to be fun. And as you know, people that you want to get in the end, we always are getting new members. So it's only as good as the people that we get in here. It's just going to be fun. And it's just like, I'm on the library board at home. All we do is good. All we do is good. And all the end does is good. And thank you for doing good with us. And you're excused. Thank you.